Hi, IP licensing class. This is Professor Opterbeck, and this is the first video that will make up for our October 18th class. And I want to talk very briefly in this video about rights of publicity, and then I'll mention some other things about copyright. So let's talk a little bit about the legal background for the right of publicity. Now, the right of publicity is pretty interesting. It's not a traditional type of intellectual property right. When we think of the traditional domains of intellectual property, we're thinking patent, copyright, trademark, trade secret. And the right of publicity, kind of overlaps a little bit with copyright. The textbook, the casebook mentions a sort of overlap with, say, characters like Superman or Spider-Man or something like that. Actually, I don't really think that's an overlap with the right of publicity. I think that's not quite an accurate statement in the casebook. It is true that a well-defined and developed character like Spider-Man or Superman can have copyright protection. And we're generally talking there of fictional characters or perhaps personas that are sort of connected to a real person but not quite real, like maybe a professional wrestler's persona, right? And those characters are potentially copyrightable. That's not really a right of publicity, but it is sort of an adjunct in the sense that there's something about a persona, right, that is potentially protectable. The book also talks a bit about the somewhat overlap with trademark, because as we talked about last week, trademark is the goodwill of a business in a word, name, symbol, or device that identifies the source or origin of a product or service. That is rooted in the common law of unfair competition. And so a right of publicity is not a trademark right, but somewhat similarly, it is rooted in common law. And in many states, it is also the subject of statute, and those statutes tend to be really encoding and then expanding upon the common law. And a lot of that common law, again, goes back to that common law of unfair competition. I mean, the 18th or 19th century common law of unfair competition is pretty sort of amorphous. Unfair methods of competing are unlawful, and it's kind of left to the courts to specify what that means. And in some cases, that can mean using, particularly in the traditional vein, a celebrity's name, image, or likeness in a commercial venture. Now, I'll just skip to this point for a minute. Today, in most states, in the common law and or in the statute, the right of publicity is not only restricted to celebrities. So it is somewhat broader in most states, but that's sort of the common law route. Okay, so it is not a traditional type of IP. It is basically a creature of state law. There is not a federal right of publicity statute, and it can be common law or state statute. So the details really depend on state law. As we said, it has a common law derivation, and it includes using the name, image, likeness, and related features for commercial purposes without permission. These are the general elements of most right of publicity common law causes of action or statutes. All right, so you will have heard this term, name, image, and likeness, probably, certainly if you're into collegiate athletics, because this idea of nil, name, image, likeness is a big deal in college athletics. I'll talk about that in just a moment. All right, so note that the use is for commercial purposes. Right? This is important because uses of name, image, likeness, and related features for purposes that are not commercial but are newsworthy, right, is not generally going to be a violation of the right of publicity, even if the news outlet is also a commercial venture. So, let's say you are a lawyer involved in a high-profile case, and there's a photograph of you, escorting your client from the courtroom as the proceedings are going on, and that photograph makes it into the New York Times. That's not going to be a right of publicity violation because the discussion of the case, it's related to the news discussion of the case, even though the New York Times is making money. Now, if your photo is used in a New York Times advertisement, right, or in an advertisement on the New York Times website, that's different, right? Okay, and in that case, then we also have this element of without permission. And this idea of without permission is going to relate to what we'll talk about in just a moment, which is the right of publicity is something that can be licensed. So, if you are a model and you are appearing, in an ad for, a clothing manufacturer, and you're posing wearing the clothing, well, you would have presumably have signed some kind of form that is giving the permission to use your name, image, or likeness in that setting, right? So it's without permission. You can bargain it away. Now I note here related features, and there are some cases involving other identifiable features of a person, for example, of their voice. Right now, although these laws are not usually limited to celebrities, and they're not trademark laws as such, when you get to a feature like a voice that is kind of disembodied, you're starting to get away from the traditional privacy concern of having yourself, imaged or pictured in some way that's commercial, that you don't want, right? A lot of those cases, the feature has to be identifiable to the individual. So there was a case, I believe, involving Bette Midler, who had a very distinctive sort of vocal styling, right? And in that kind of case, there may be some requirement of it being identifiable to a specific person that's a little different than the general name, image, and likeness. Of course, all of these, if there's a case that arises, the statute might specify some statutory kind of damages, or if it's a common law case, you'd still have to show damages. So even though these statutes aren't limited to celebrities, for the average person, the damages are likely to be slight. Even if someone did use your picture as a lawyer in an advertisement, if you're not a famous celebrity lawyer, it might be that the royalty that you would get for that is relatively small, but you'd still potentially have a claim. Okay, so let me talk for a moment about nil in the NCAA context, and this is an instance in which our casebook is woefully out of date. So ignore everything the casebook says about that. We now do have the O'Bannon case in the Ninth Circuit, and then the Alston case in the Supreme Court in 2021, which the Alston case did say that the NCAA cannot impose a blanket ban on nil payments, name, image, and likeness payments for college athletes. Previously, the NCAA had a blanket ban, a rule that banned athletes from receiving nil payments. So as we all know, and as a Seton Hall basketball fan, I rue this Alston case, because I just think nil is really destroying the ability of kind of a middle market university like Seton Hall's undergraduate to compete in a top tier division like the Big East against schools that have more resources for nil. It's I don't know. I hate it, but there it is. It's what it is. But the NCAA still does impose some limits, and in particular, the limit that is imposed is that schools may not pay student athletes directly. So what schools do, and Seton Hall University has this, is some kind of third party, some kind of consultant who is set up as a clearinghouse to connect athletes with nil opportunities. So if you were like a New Jersey car dealer and you wanted a star player from the Seton Hall basketball team to appear in your ad, you could go through that portal and you'd be connected with that athlete, and you'd be able to pay that athlete. You could even have an athlete come talk to your church potluck supper or something if you want, right? So you can do that kind of thing. The school can't pay directly. There is currently litigation which in front of the same trial court judge who originally decided the O'Bannon case, which is a big class action, arguing that even that rule should be stricken down. Class certification was just granted in that case last month. That's going to continue to be litigated. I don't pretend to be an expert in this area, but my understanding from people in the field is that the expectation is that the NCAA will lose at the trial level, and given the unanimous nature of Alston, they're likely to lose at the Supreme Court too. So we very may well see the NCAA not able to impose this rule, and colleges then having to start directly paying their athletes. Now, again, this all depends on your perspective. As a college basketball fan, I think this is horrible. But the only way for that to change will be for Congress to intervene, because all of this relates to the antitrust laws, which are creatures of statute. Congress could intervene. I don't see any will in Congress to do that. All right, all of this to say, just be aware, this aspect of right of publicity and nil in the college context in our casebook is outdated, and certainly there are lawyers practicing in representing college athletes in negotiating nil deals, and that's all perfectly legitimate. All right, the right of publicity can be assigned, and it can be licensed, and a license can be exclusive or non-exclusive. You may have seen, you may have attended an event at some point or another, or if you haven't, you will at some point or another, where there's some notification that the event might be recorded or photographs might be taken, or you may have had to sign a release form, or it might be on the back of your ticket or something like that. It's usually qualified or written as a release. It's not really a release. It's really treated as a non-exclusive license. I mean, a release assumes that you've got some existing claim that you're then releasing. That's usually what we mean by a release in a legal context. But in any event, styled as a release, what it is a non-exclusive license. So very, very common. You're attending, some CLE event or some charity dinner, and there's an official photographer, and there might be photographs on the organization's website, and there's somewhere release. If there isn't, by the way, if you're representing that organization, you need to make sure they're getting releases in some way or another so that they can go ahead and do that if they want to. So a release is a license. Now, I mean, it is possible, and the casebook mentions this, and I think usefully, it's possible to assign a right of publicity. Ordinarily, from the perspective of the individual who has their right of publicity, it doesn't usually make sense to assign it. I mean, it's not something you usually want to just completely give away. It almost feels like a kind of indentured servitude in a way. More likely, and the more common transaction, is a license. It may be exclusive for certain purposes, and/or it may be non-exclusive depending on what the deal is. Now, just a note here as well, for pro sports, something you want to keep in mind is that rights of publicity, particularly as they are connected with a team's trademark rights in the team branding, are usually subject to some kind of collective bargaining between the players' union and the league, and you just need to be aware of what that allows and doesn't allow if you're involved in a deal. And I'll just tell you, my one experience with this was with a former New York Giants player named Jeremy Shockey, who was a tight end. This was a number of years ago, right? Probably 20 years ago at least now. And there was a company that made watches that wanted to have him as their spokesperson. They made a watch called the G-Shock, right? So Shockey was the G-Shock spokesman, and I represented the company that made the watches, and so I had to negotiate with Shockey's agent for the nil rights, right, for the publicity rights, and what the parameters of that were. And because of the collective bargaining, though, we couldn't. He was playing for the New York Giants at the time. He couldn't be wearing a New York Giants uniform or show the New York Giants logo. So he could wear sort of a generic blue uniform, but not the Giants uniform, unless we negotiated a separate deal with the Giants, which the client didn't want to do at the time. So that was interesting. And by the way, some of those deals, depending if it's a celebrity or an athlete, they may have other clauses beyond just the license terms. For example, a morals clause. So it's not uncommon if you're having a spokesperson to say, particularly somebody who's sort of on the edge a little bit, like a rock star or certain sports celebrities, if they act in some way kind of contrary to the best interest of the brand, like they get arrested or something, right? That can shut down that deal. And so that's sort of like an ancillary term in some of those licenses. Okay, let's talk about copyright for a second. All I'm going to do in this video for copyright is point you to some other things. So I posted the Intro to IP interactive video earlier last week. So if you are not up on copyright, go to the section on copyright in that Intro to IP video and take a look at that, and you'll get a better background of what the law of copyright is about. I have also posted in a folder specific to this week the interactive videos from my copyright law class on copyright transfers, copyright term, and copyright termination. So transfers is assignments and licenses, right? And there are specific things you need to be aware of in copyright law about that. And then copyright term, how long a copyright lasts, and termination, which is throughout the life of the copyright term, there is always, and if there's a transfer made, right, some point, a license or an assignment, I'll just put LA here, license or an assignment, there's always a point at some time after that in which the original copyright owner or the original copyright owner's heirs can actually cancel that transfer, cancel that license, or cancel that assignment. And that's really important to know when you're doing a transaction that involves copyright. Now, in the notes on those videos that I posted on Blackboard, I'm telling you what you need to focus on and what you sort of can just watch quickly, because not everything in those videos is completely relevant to this class, but you can look at those notes and get a sense of that. And then finally, there is a discussion board posted for this week. That discussion board is going to serve as your attendance for this fully online asynchronous week. So I want you to post some response to that. That's around 500 words or so. It can be some bullet points or some other things. It doesn't have to be a big eloquent thing, but a response that shows you've engaged with this material and have some thoughts on it. When I see that response, I will mark you present for this week. All right, enjoy this week, and then I will see you next week.